Good evening. This side Rahul Magan here as a Group Chief Executive Officer, Treasury Consulting. As we speak, Treasury Consulting is a multinational headquartered group based out Singapore. We are a multinational hedge fund who actively take positions in multiple locations of the globe. But having said that, we are proprietary in nature. By proprietary, I mean to say no third party. I repeat, no third party is allowed to invest capital in our fund. Please do take a note that Treasury Consulting do not invite investments from any third party. Please do take a note of that. In my earlier videos, I had a word about difference between expert agreement and arbitration agreement. And to be honest, it is really difficult even for experts, at least apparently speaking, to differentiate whether this agreement is an expert agreement or it's an arbitration agreement. Unfortunately, we all are aware that even though tons and tons of theses, notes, and books written available on Amazon, but still contracting in done is a very lethargic manner. End result arbitrations, dispute, court proceedings, litigation cost, time waste, project losses, and whatnot. In fact, in some cases, we have seen arbitration to the tune of thousands of crores, not 1 crore, 2 crore, 3 crore, thousands of crores. Please understand that when you are talking about expert judgment, it means you are referring an expert in a game. But when you are talking about arbitration agreement, then you are entering an arbiter in the game. So let me define you something as per the law book. A contractual provision for dispute resolution by an expert doesn't amount to an arbitration clause, even if it is termed as an arbitration clause. And this is what I said, that if you are using a word arbitration, adjudicate, arbitration tribunal, presiding arbitration, arbitrator, presiding panel, this doesn't mean that your contract is tantamount to as an arbitration agreement. You need to justify in writing. Writing means whatever you wrote in a contract that it differentiates from an expert level agreement. For that, we should be thank you to Supreme Court of India. Honorable Court mentioned few points, point by point, which help people, those who are drafting the contract, to differentiate between expert level and arbitration level contracting. But before that, I would like to read one important paragraph, which is the expert valuation carries binding efficacy unless fraud or manipulation is proved. Yet, the expert determination doesn't have the status of a court degree for the purpose of enforcement. The arbitrators enjoy judicial immunity. Like I said, in case of arbitration, the court have unlimited powers because it is covered under the respective arbitration act of respective country. Before I raise the points, I would like to thank you, Supreme Court, Honorable Apex Court, for giving a point to point reply which helps people, those who are drafting the agreement, whether they are drafting expert level agreement or they are drafting arbitration level agreement. If I go with the law book, then Supreme Court, Apex Court mentioned like this. The Supreme Court has examined the attributes which must be present in an arbitration agreement, which differentiates between expert determination and arbitration as follows. Among the attributes which must be present for an agreement to be considered as an arbitration agreement are: point number one, the Honorable Court saying the arbitration agreement must be contemplate that the decision of the tribunal will be binding based on the parties to the agreement. By tribunal means arbitral tribunal. Honorable Court saying in second point that the jurisdiction of the tribunal to decide the right of the parties must derive from the consent of the parties or from the order of the court or from a statute, the terms of which make it clear that the process is to be an arbitration. Point number three, the Honorable Court saying the agreement must contemplate that substantial rights of parties will be determined by the agreed tribunal. Point number four, that the tribunal will determine the right of the parties in an impartial and judicial manner, with the tribunal owing an equal obligation of fairness towards both sides. Point number five, that the agreement of the parties to refer their disputes to the decision of the tribunal must be intended to be enforceable in law. And lastly, last but not the least, the agreement must contemplate that tribunal will make a decision upon a dispute which is already formulated at a time when the reference is made to the tribunal. Please do understand that when you are drafting an arbitration agreement, you are supposed to be very clear about the role of the arbiters, who would be the arbiter, whose authority to appoint the arbiters, the professional qualifications of the arbiter, whether there is a need of presiding arbiter or two arbiters are okay to handle the situation, whether there is a need of arbitral tribunal, basically a judicial body to reach, whether there is a need to mention anti-arbitral injunction in the agreement, whether there is a need to mention anti-arbitral injunction in the agreement. These things look very difficult. And I'm not saying they are easy, let it be honest. But if done immaculately in this regard, you would be able to save your basically your contract, your money, your efforts, your dignity, your PR in a very, very best way. So guys, please do understand that when you are making a contract, pricing is definitely an important thing. I completely in sync. But having said that, key consideration should be given towards the arbitration clauses. To conclude, the other factors which are relevant include whether the agreement contemplates that the tribunal will receive evidence from both the sides, hear their contentions, or at least give the parties an opportunity to put them forward, whether the wording of the agreement is consistent or inconsistent with the view that the process was intended to be an arbitration, or whether the agreement requires the tribunal to decide the dispute according to law. I would like to conclude my deliberations with the fact that on time to time basis, honorable courts in India and honorable courts across the globe give their respective judgments on the arbitration. Arbitration is a vast ending concept because every day a new case, a new issue, a new dispute came before the court of law. And court need to go with the principle of natural justice. Court needs to see each and every angle of the dispute. Court needs to consider the expert issues in this agreement. Court also needs to see why the dispute arises, whether it is because of plaintiff or it is because of defendant, and court need to see each and everything from a 360-degree angle. Henceforth, it would always be better that if we continue to do our research on the social media, and we are very fortunate that we have Google, we have LinkedIn, we have YouTube, we have now Amazon, where we have a lot of books, we have different websites who continue to update all this. It would always be better if we continue to update ourselves, because arbitration is a very vast ending subject. A manufacturing dispute, say X, is completely different when it comes to the manufacturing dispute Y. So apparently speaking, both are manufacturing dispute. X is manufacturing dispute, Y is manufacturing dispute, so the resultant should be the same. But having said that, even though both are manufacturing dispute, the nature of the dispute differs. The entitlement differs. The awards differs. The way we look differs. Henceforth, if we are in a world of agreement, especially we are a law firm, probably we are a consulting firm, we are a corporate law firm, or probably we are a full-fledged arbitration firm, it would always be better if we continue to upgrade our drafting, because drafting is endless. Sky is the limit. If you think you achieved best in the drafting, then you need to see the more good drafts. Drafting is endless. The more input you would be putting, the better output you would be getting. To conclude, I would like to request people that, like financial markets, foreign exchange, non-deliverable contract, option derivatives, forward rate agreements, deliverable contract, central bank decision, hawkish, dovish, owlish, and all these technical terms, arbitration is also highly, highly, highly technical in nature. Because once you download the dispute, which is nowadays available on the internet, there are a lot of websites who are providing the copy in the PDF form, and you study them, you get lot of interesting things and clarity. This is what I would like to say. At the end, I once again thank you to the Honorable Court for jotting down the points which will help to differentiate between expert agreement and arbitration agreement. This is Rahul Magan.